watch at a later time on our website. For those that are joining by computer, if you have a question for any of the speakers, please submit your questions in the Zoom chat or in the Q&A box at the bottom of your screen. For those joining by telephone, if you have a question that does not get answered by the end of our program, please call the HBE office and leave a message with your question, and one of our staff will follow up with you to answer your question. To start today's program, we'll have a short presentation to give an update on a new segment for our Spring Lunch and Learn series, which is brought to you by our HBEC Community Advisory Board member, Mr. Jim Bridgeforth.
Are you ready?
We are ready. Go ahead, Mr. Bridgeforth.
Okay. Today I'm going to make a presentation on two bills that's before the Senate that are very important to voters around the nation. The first bill is H.R. 1, and it's called For the People. This bill addresses voter access, election integrity, election security, political spending, and ethics for the three branches of government. Specifically, the bill expands voter registration and voter access and limit removal of voters from voter rolls. The bill provides for states to establish independent, nonpartisan redistricting commissions, addresses campaign spending, including expanding the ban on foreign nationals' contributions to spending on campaigns and election, expand disclosure rules related to organizational spending during elections, campaign ads, and online platform. It requires candidates for president and vice president to submit 10-year tax returns prior to running for office. Now, this bill primarily is to address some of the loose money, that's dark money that's running around in campaigns, and also to make campaigns more people-oriented so that big money is not buying the candidates that are running for office. So it's more in the line of disclosure, accountability, and also to make sure that people know who's funding these campaigns for people who are running. Right now, we have a situation where they buy the candidates and put them up, and we vote for them. So we want to return, this bill is to return the power back to the people so that the people will decide who get elected. And a good example of how unresponsive our electors or legislators have become is this stimulus package, noting that not one Republican voted for it. And so that shows that there's not a great deal of accountability to the people because the people overwhelmingly wanted this bill. So we encourage you to support and let your legislators know that, and we're going to put up a slide as to who to contact. They have one here, and let them know that you are for the passage of this bill. The next bill is the John Lewis Voting Rights Advancement Act. It restores the full protection of the original Voting Rights Act of 1965, which was last reauthorized by Congress in 2006, but was gutted by the Supreme Court in 2013. The part that was eviscerated by John Roberts' court was the requirement that states get approval from the federal government before they start enacting or changing voter requirements. So they decided that we had come a long ways and there was no need for this portion of the act anymore. And obviously he was wrong, as you can see by Georgia and 43 other states enacting laws that are penal to people who want to vote. So this bill, what it does is restore the full protection of the original Voting Rights Act of 1965. It provides tools to address discriminatory practices and seek to protect all Americans' right to vote. Creates a new coverage formula that applies to all states and hinges on the finding of repeated voter rights violation in the preceding 25 years. It increases federal power to deal with violations of the act. So again, it's really reiterating or restoring to the 1965 Voting Rights Act what was supposed to protect voters. The irony of this is that it seemed to me that Republicans are trying to direct their fire towards minority voters, but their efforts are going to hurt all voters. So we have to get behind them and let our legislators know that we support these two bills. Now, the problem that we're running into with these bills, you heard a lot about the filibuster rule. The problem is that under this filibuster rule, and what is a filibuster? A filibuster is any attempt to block or delay Senate action on a bill or other matters by debating it at length, by offering numerous procedural motions, or by any other delaying or obstructive action. This action prevents a simple majority of senators from voting on and passing bills. So right now, we're locked in this situation where the Senate is 50-50 and the tie breaks by the vice president. But with this voting, the only thing that can kill the filibuster is cloture. And a cloture vote requires that 16 senators file for cloture, and this cloture is to end the filibuster. And then it allows a period of a day and 30 hours of debate before senators can vote on cloture. Then it requires 60 senators to vote for closures. And you realize then what an uphill battle that is, because if they're 50-50 and we can't get the Republicans to vote with the Democrats or the Democrats to vote with the Republicans, then that becomes impossible for the bills to pass. So where we are now is whether or not we're going to, the Democrats are going to work around the filibuster rules and try to get stuff done. Now, it becomes very important that we become active in terms of letting our legislators know where we stand on this. I think we have a slide here that shows the Michigan senators and representatives. Okay, these are the people that we need to contact, and you can do it by telephone and just let them know that you support the passage of this bill, and also if you support it, and also that you are in favor of not allowing the filibuster rule to get in the way of these bills passing. So I'm encouraging everyone, and we need to have something done about the fact that these states, as I said, 43 of them, at least I think 43. Michigan is now becoming one of them that's trying to pass the draconian's Voter Rights Act. So this concludes my 5-minute presentation. Any questions? I've tried to give you a broad overview of this information, but if you're interested, you can go on the computer and find more detail about these bills, and you also more about the filibuster rule. But the main thing to remember is that nothing will get done unless we get rid of this filibuster rule or find a way to work around it. Now, just one other issue, and I'll be done, is that we were able to pass the stimulus package because there's a rule that says that if there's a budget bill before the Senate, then filibuster can be worked around by what they call reconciliation. So the Senate got the stimulus package passed through reconciliation. Now they can't do that with these bills because these bills do not relate to finance. So that's a big problem. So anyway, we need you to, if you will, contact the legislators and let them know how you feel about this. So that concludes my brief presentation. And I think I stayed within the 5 minutes rule, 10 minutes rule. So any questions or anything?
Thank you so much, Mr. Bridgeforth. If anyone has questions, please enter them in the chat or the Q&A box, or you can always call our office and we will have someone return your call. We'll now begin our first presentation. Our first speaker today is Ms. LaToya Hall. LaToya is the director of the Successfully Aging Through Financial Empowerment Program, or SAFE. SAFE educates, coaches, protects, and empowers older adults and caregivers who need help managing their finances. SAFE can help prevent fraud and identity theft, as well as assist in recovering identity and funds if you have been a victim. We'd like to give LaToya a warm welcome and a big thanks for sharing important information on COVID-19 related scams with us today.
Hello and thank you, everyone. As Vanessa said, my name is LaToya Hall. I am from the Successful Aging Through Financial Empowerment SAFE program. I am the director for the program. Today, we will be talking about some COVID-19 scams. What are some of the things going on? What to look out for, how to protect yourself. With COVID-19, as much as it has been a catastrophe for most of the world and a very hard situation to deal with, it still hasn't stopped scammers and dishonest people from looking at this as an opportunity. And so we wanted to bring to you how to protect yourself from some of the things that they are trying to do to carry out their dishonest practices. Next slide, please. So there are a few, I just want to start off with talking about some of the different types of scams. So these scams, many of them are modeled on scams that you see all of the time, but they've been adapted for COVID-19. I put at the top of the list tech support scams because most of us are online a lot more these days. I mean, even being here doing this lunch and learn online and not in person really shows, you know, how much most of us are really doing almost everything online these days. And so with this surgence of people going to online for most things, there are a lot of people that are using that as opportunity to scam people. And so there are a lot of tech support scams going on. And what that usually looks like is you're on your computer, you're doing something, you're going, say you're perusing just websites for cute dogs or something, and you get a screen that pops up and it looks down here like this little one. It says, warning, system may have detected viruses on your computer. You get something that's a blue screen, the white screen with red writing. Sometimes they'll do a blue screen. They do different things, but the idea behind it is they're telling you that something is wrong with their computer. And what you need to do to fix this is you call this number or you click this link and you pay us. And then you let us remotely get onto your computer. So you share access with your computer, to your computer with us, and we're able to go on your computer and fix what's ever wrong. So of course they're able to go on and say they fixed whatever was wrong because they put what was wrong on there in the first place, if there was anything wrong. They also, if you pay them, they'll charge sometimes upward of $200. And then not only, you know, have you paid them for something that they did or something that wasn't wrong, they also ask you to let them onto your computer remotely to fix it. And then they're able to go through all of the private information that you have in your computer. So any stored passwords, if you're not, say, clearing your cache and cookies and you're putting information into forms and things, they're able to go through all of that and get so much personal information. Then with the latest legislation that passed with the stimulus package, there was a economic impact payment with the stimulus package where everyone got $1,400. Well, people are doing scams on that economic impact payment. They're calling people saying that they're processors and they need information to process the payment. And so they're getting a lot of information out of people that people would normally give over because they're thinking they're talking to someone who's going to process their payment. Just a few things to think about. The IRS isn't calling people to process stimulus payments. If someone does call you, you know, you can always politely decline their call and hang up. I do talk a lot about phone calls in some of my other presentations. And I do want to say with phone calls, the best defense is not answering numbers you don't know. However, if you should answer and there's someone on there saying that they have an economic impact, they want to call to talk about your stimulus payment, as they call it, or some type of grant or any of these things, you can politely decline or impolitely decline and hang up the phone, because that's usually a scam. COVID-19 relief grant scams. I've been getting a lot of people asking me about this. Are they, someone told me they were giving relief grants or this grant or whatever for COVID-19, and you can get up to $250,000. Even my dad called me about it, and it seems that they're telling people that, you know, they can get this money and all they have to do is fill out an application for these grant funds because it's for COVID-19 relief. And I can help you fill out this application, and it just costs $30. So now they have a payment for application for a grant that doesn't exist, and you pay them, plus they have all of your information because you've given them so much information to put into the grant form, and they have financial information for whatever electronic form of payment you use to pay them. So really watch out for that. To my knowledge, outside of, you know, I think there are even loans, like the business loans and things for COVID-19. I don't know of any like personal grants to individuals where they're going to give you $200,000, $300,000 just in response to COVID-19. Government imposter scams. I talked a little bit about that with the economic impact, or, you know, these are government officials are calling you to warn you about, you know, either it's the IRS or someone from Social Security or someone from the Unemployment Administration. I got a good one today. Someone called me and said someone had called him from the Social Security Administration. They were a Social Security detective, and told him that his Social Security number was being used. It was being used to rent a house, and there were some illegal activities going on in this house, and he was going to be in trouble, and they rented all these cars and did all of these things. As I said before, no one's really going to call you with information like that. So be really careful what you're letting people tell you is going on if you were to answer one of these calls. But they're always almost calling from a government entity or organization, and something's wrong or they need your help with something. Then you have private business imposter scams going on a lot, where people are calling and they're saying they're calling from the power company, they're calling from your bank, they're calling from any numerous like private business place, and they want you to, you missed the payment, you need to pay again. There's something going on with your account. They want to verify with personal information. Watch out for those calls as well. COVID-19 vaccine scams. These are really popular. And I don't know, we're getting a lot of the older adult population vaccinated at this point, which is good. But I know very early on, like people were calling people and saying they were calling to help them to schedule vaccine appointments for a fee. They could, for a fee, move them up in the vaccine line. Just know that those calls are scams. Like, no one's reaching out for you to pay them a fee so that you can get the vaccine. The vaccine is free to you. They can bill your insurance, but you should never have to pay out of your pocket for the COVID-19 vaccine. You shouldn't have to pay someone to sign you up for an appointment for the vaccine. No one should be calling you requesting personal information to get you in the vaccine rotation or anything like that. If you think your doctor's office or someone like that is legitimately calling to get you vaccinated or kind of like in the process, what you want to do is you can politely decline that call again, and then go and find an independent number that you have from that entity to call back. So say they're calling from your doctor's office, go and find the number that you use to call your doctor's office and call them and ask them, you know, is there something going on? Did someone call me? Is there a problem? You really want to be careful about taking incoming calls. And that's not only for the vaccine scams, that's for anything. When you get an incoming call of that nature, you really want to be careful about sharing information or financial information with them. Another one that we've seen is a sick relative scam. And that's where, you know, it's a play on the grandparent scam. So it used to be someone would call you up in the middle of the night and they act like they're a grandchild that's in trouble. You know, either I'm in jail or I'm in some type of trouble and I need money. You can send the money to my friend and then they could buy me out or do whatever they need to do to get me out of this trouble. And then they end with saying, well, don't tell anyone, especially not mom or dad, because I don't want to be in more trouble. So you really want to be aware of those calls. They've changed it a little bit with COVID-19. Now they're calling saying that they're a sick relative or a sick loved one, they're sick with COVID-19, and they need money for healthcare related expenses. So that's the new spin on the grandparent scam. Still kind of the same thing, but the spin is, Auntie Bev, Uncle such and such, Grandma, Grandpa, it's me. I'm sick. I have COVID. I'm in the hospital and I need money for whatever type of care that they're giving me. Could you send the money to my friend or someone to help me out with this medical care that I need? Be aware of that is going on. If you should get a call and you think it is a loved one in trouble, I always suggest verifying. So sometimes you can just call the number that you have stored in your phone for that person, and they'll tell you that they're personally fine. Call their mom or dad, call other relatives who have close contact with that person, but be very careful about just sending money for those things because people are doing scams of that nature. And then something else that we've seen a lot of are romance scams. So a lot of people, in the house alone, maybe feeling lonely, reaching out to find love, especially online and things. A huge surge in online dating. But people are taking advantage of that, setting up fake profiles, acting like someone that they're not, acting like they're in love with people and getting them to send them money and valuables and things like that. So you really want to be careful about meeting new love interests and what you're willing to share and how much you're willing to share financially. So it's nothing wrong with meeting a companion or someone to talk to, but just think about it when this person starts to ask you to share a lot financially. A good one that they do is, I really want to come see you, but I can't afford travel. Why don't you send me $3,000, $4,000, $5,000 for a plane ticket and I'll come. You send the money and they never come. Just really watch out for those new romantic interests that are always talking about cash. Next slide, please. So I want to go over, I talked about a few of the scams. These are the most common methods of contact that we're seeing right now. The number one is phone calls. That's always been the most common method of how these scammers contact people, and it's continuing to be the most common method. A lot of scammers, the first and initial contact is over the phone. And so that's why it's very important with those phone calls to remember, if you can avoid answering numbers that you don't know, don't answer those numbers. If you can put yourself on the do not call registry, that is a good idea. And so I always get pushback from that because I always get people say, the do not call registry doesn't work. I'm on there and I'll still get calls. And I'll say, well, the way that the do not call registry works is that if you are on the do not call registry, you can be almost 100% sure that legitimate telemarketers aren't calling you. Legitimate telemarketers are paying attention to the do not call registry. They do not want to be fined by the FTC and have all the problems that come with ignoring that registry. However, scammers don't even have access to know who's on the registry. So scammers are still going to call. So something that going on the do not call registry does for you, it lets you know that if you are receiving telemarketing calls, you can be almost 100% sure that those are scam phone calls, okay? Email is another common way that they reach out. You really have to be careful about the emails, especially emails about, the vaccine, or there was one going on about contact tracing very early in the pandemic. They asked you to click links. Please beware that clicking links can take you anywhere outside of where it says the link is supposed to go. And you can also be clicking to download harmful software onto your computer called malware that I'll talk a little bit more about later. They even send text messages to scam now. So really watch out at what text message you're getting and what they're saying and where they're asking you to call back. Some of the text messages will ask you to click a link and it'll serve the same purpose. Facebook messages is a huge one. My dad, when he got reached out to about the the government grant scam, the message, it came through a Facebook message. So really watch out for Facebook. A lot of people are on new to Facebook, my dad included, and it's something that a lot of us probably would not have had if it was not for the pandemic and all of kind of like the social isolation going on right now. And so you really want to watch out. Something you need to know is that anyone can use a picture and make a Facebook profile and say they are anyone that they want to be. Just because it says your old friend from high school is messaging you in your inbox, it doesn't necessarily mean that it's that person. So really look at those messages, look at the grammar, look at the spelling of words, look at how they're presenting things. And then really think about if this is someone, you know, who wants to kick the breeze and talk about old memories, or is this someone who's trying to sell me something or get me involved in some type of get rich quick scheme? That'll usually tip you off. If someone starts asking about money, I don't care if it's the real person, you might want to, you know, especially if it's someone that you really don't have that close of a relationship with, please get out of there. And then phony websites. I think you guys remember like very early in the pandemic, they were talking about phony websites selling the things we couldn't find, like personal protection equipment or disinfectant supplies. So really watch out for what websites you're going to and where you're buying stuff, and do your due diligence that way. Next slide. So I talk a lot about people asking you for information. And the reason that I talk about that is it's a tactic that's called phishing. Because I talk to a lot of people and they'll say, well, I didn't give them any money. But then when I talk to them, that I realize that they've given this person so much information that they did not have to give them money. And so you really want to watch out about what you're sharing with people. They may contact you by phone, email, and maybe a fake website that you go on, you know, you get a text message. Just be careful about the information that you're sharing with unverified sources. You never want to share too much, especially now with incoming phone calls or someone contacting you. People will try to get banking information, credit card numbers, passwords, social security numbers, and all types of other things. And they're just talking, they're casting that rod out there and they're seeing what they can reel in. We call it phishing. So beware when someone gets to asking you for all of those personal questions, especially when it's someone who reached out to you. Because when you call someone, you kind of know who you called. Granted, you want to call your bank, you get your bank card and call that number on the back of the bank card, you're pretty sure that you called your bank. When someone calls you, you don't know who's on the other end of that phone, where they're calling from. And a lot of people will say, I have caller ID, but with today's technology, the caller ID really doesn't matter anymore. It's sad to say. It can give you an idea of who it is, but people have ways, they call it spoofing technology, to mask caller IDs. So I can call you from my cell phone and make it look like I'm calling you from Venezuela if I needed to. So really be careful about sharing information with people who initially contact you. Next slide. And I told you I'd talk to you about malware. So malware is harmful software that's downloaded onto your computer. It can do a few things. It can disrupt the operation of your computer. So you ever had a computer and it was working fine one day, and then the next day it started moving slow and shutting off by itself, and all of these crazy happenings start to begin? The chances are that you've downloaded some malware software. And that's usually going to happen by you clicking on some link that pops up or someone sends you an email. It can gather sensitive information. So it can go through your computer and go and find things that you've typed into websites, stored passwords, all types of sensitive information. It's stored in the cookies and cache of your computer, and malware allows someone to go into your computer and get these things and get access to this information. People can begin to impersonate you and go into your accounts to send spam messages or fake messages or things like that if they have malware in your computer. I talked about the remote access, like they can have remote access to where they're in your computer and doing things through your accounts as if they are you. And then gaining access to private computer systems. Next slide. So you want to think about, well, malware. Think twice about clicking links or downloading anything. And not saying that you won't have to click links sometimes, but you really want to know what you're clicking and know that it's from a trusted source and know where it's from. Especially with pop-ups too, because a lot of times we'll get things to pop up. Click here for this, click here for this. The best thing that I can tell you is if you don't know where that pop-up came from, like you're just on the computer and all of a sudden something pops up for you to click in, just X out and get out of there. Beware of pop-ups. Watch what you're downloading when things, you're trying to, and it happened to my niece. She was trying to watch like free TV and it asked her to download some software and she went to download it and it put malware onto her phone and she had to get it cleaned up. So, that's just one example. Be careful of what you're downloading. Make sure you have updated antivirus software. So this one is tricky because sometimes you'll get a pop-up saying, click here to update your antivirus software. Stay away from those pop-ups, but you know that you can find antivirus software to download, or you can go and purchase antivirus software to put onto your computer. Make sure you're using strong passwords for your logins, and make sure different services or places where you log in have different passwords. It's more secure to write down your passwords and keep them in a secure place than to use the same password for everything. Because all it takes is someone to guess one password, and then they have the password to all of your accounts. So be careful with that. Next slide. Another one that I seen that I kind of like put in a class of its own because I want to talk more about this. Assistance with shopping and running errands. And I saw this a lot earlier in the pandemic. I think as more people are getting vaccinated, they're resuming their regular activities or going out really early and getting what they need. But I do want to talk to people about this because it's one that I kind of saw a lot of. And it's people going door to door calling, and they're offering to do shopping for people. And what they do is they ask for cash, or they ask for a debit card or bank account information. They take a grocery order, and then they never deliver the groceries or return the money. Okay, a few things you want to know, just if you are going to trust someone to do this task for you, use a family member or maybe the neighbor, someone that you can trust, someone that that you can trust. If you can, try convenience apps. Instacart is a good one. Kroger has delivery on their app. Walmart, you can get delivery from their app, but there are ways to get your groceries without going out. You do have to pay a delivery fee, but it beats getting someone to do it and they don't bring your groceries and never return your money or start using your bank account or debit card for something other than what was intended. So know that those services exist if you're looking for ways to get your groceries and get the things that you need. Try some of those services. Next slide. So just a few things to remember, and then we're going to open up for questions. If you are getting robocalls, if you answer, just hang up. But as I mentioned, the best way to handle those calls is try not to answer numbers that you don't know. And once you stop answering the numbers that you don't know and they stop thinking that there's a live person on the other end of that phone who's going to pick up, you'll start to get less and less calls. Don't share your Social Security, bank account, Medicare, credit card, or driver's license numbers with people who are contacting you or reaching out to you. I don't care where they say they're from. You're from the state of Michigan Department of Collections. Okay, I'll figure it out. You can hang up that phone and you can go to Google and go to the state of Michigan Department of Collections, and they'll give you a number for the state of Michigan. You'll be able to go to the state's website and get a number. So just really verify, who you're calling. But when someone calls you, I don't care where they say they're from, you want to be very sparing in what information you share with them. Don't send money to people you don't know or without verifying that it is going to the right person. So, just because someone calls and says they're your grandson, Johnny, and if you send money to their friend, they'll get it. It may not even be your grandson, Johnny, that called you. So you want to definitely verify that the person you think is getting the money is the person who's getting the money. You don't have to pay to receive or sign up for COVID-19 vaccine. Try to stay away from hiring strangers to run errands for you. Next. Okay, one that I failed to mention in the stimulus payment scam was they say that they can get your stimulus check. So I'm going to get your stimulus check and I'm going to send it to you. And then they let me get your bank information and make a deposit. Then they make a deposit. Oops, our deposit was $1,800. Your stimulus was only $1,400. Why don't you send us the $400 back and keep your amount? Okay, it's surprising as it may seem, people will do this. But what happens is it was a fraudulent deposit that they made, and that may clear on your account in 2 or 3 days. And so you're thinking the money is cleared. Okay, I can send them this money back, but then it doesn't clear for the bank for another couple of weeks or so. So when it goes to clear from the bank, it comes back that it was a fraudulent deposit. And then you end up owing all of the money that you sent them and any money that you spent out of that. So be careful about giving people information to deposit things into your bank account, and definitely beware of someone telling them that they're going to deposit, telling you that they're going to deposit something and you send a portion of that back. Be very careful about that. We all want to help our loved ones if we can, but verify any information you received from a call of a loved one in distress. That's very important. And then know that the IRS is not going to contact you by phone about your stimulus payment. It's just like with back taxes. They don't contact you by phone. They actually have so much going on right now. I don't think they're going to contact you, and they're hoping that you're not going to contact them because they have a lot going on right now. But I can guarantee if you do talk to the IRS, you will be the one reaching out because they're not contacting you over the phone about a stimulus payment. And then, review your credit and bank statements frequently for unfamiliar charges. That's the best way to catch that something is going on. Even if you do everything and you're as careful as possible, something could still happen. And a way to determine that fairly early on and get the help that you need is to make sure that you're reviewing those statements as frequently as possible. And then you also want to make sure that you're checking your credit report for unfamiliar accounts frequently. So where you're going to do that at is www.annualcreditreport.com. And until August of this year, you can request a credit report weekly, actually. So it used to be yearly, but until August, they're going to extend that to be weekly. I got a couple of more slides. So the next slide is just some places that you can report if something happens. Your local police department, the Better Business Bureau has a scam tracker. The FBI has a division of internet crimes. If someone cons you over the internet, you will report there. A fraud fighter call center. I think that's through the U.S. Senate Special Committee on Aging. They have the Federal Trade Commission has complaint assistant, and then AARP has scam tracker. And you can report at all of those places. I'm not saying reporting is always going to lead to prosecution or someone going to jail, but it does let the powers that be know that these things are happening and what to look out for. And if something comes up and these people are caught in part of an active investigation, your report could help in getting them prosecuted. So we do offer services to anyone over 50 who is in need of economic advocacy or financial coaching in response to addressing scams and identity theft. And it doesn't only have to be a COVID-19 related scam or identity theft. It can be anything. If you need assistance, you can contact me and we will offer you no cost one-on-one assistance. We are doing everything over the phone and over Zoom right now. We're not meeting anyone in person. However, we still are offering this service. And so here is my contact information, which I will put in the chat. LaToya Hall, 313-664-2608, or l.hall@wayne.edu. Next slide. And thank you all. I'm going to put my contact information in the chat. And I guess if we have any questions.
All right, LaToya, I do not see any questions right now in the Q&A or chat, but your presentation is very timely for everybody who is on this Lunch and Learn webinar right now. When the webinar is done and you close out Zoom, and no matter what device you're using, there is going to be a window that will come up that's going to link you to a sign-up list for our Healthier Black Elders mailing lists. This link is safe. I'm letting you know it's coming because taking your advice, we want to be careful of those surprise links and clicking on that. But the page that will open up for everybody is completely safe, and we just want to add you to the mailing list so you can receive our spring, summer, and fall newsletters if you're not signed up already. So thank you very much, LaToya.
We have a question.
Hey, they are starting to come in.
Sharon Sadler, she says, what is incognito and does it help? So incognito is on your browser, on your computer. And usually what incognito does is if someone comes behind you, it automatically deletes that browser history. I can't say how much it helps as far as malware or downloading harmful software. But incognito will stop like someone coming behind you and getting on a computer from seeing what you were looking at and what was going
on. All right, that looks to be it. Thank you very much for that presentation, LaToya. Vanessa, I'm going to pass it off to you to introduce our second speaker.
Perfect. Thank you. Thank you so much, LaToya. That was fantastic. Our second speaker today is Attorney Howard Collens. Attorney Collens serves clients throughout Royal Oak and Oakland County and has extensive experience with estate planning, elder law, guardianships, conservatorships, patient advocacy, powers of attorney, trusts, wills, probate, and estate administration. He is a board member for the Area Agency on Aging 1B and the Senior and Caregiver Resource Network. He is also a member of the Alzheimer's Association Greater Michigan Chapter Wraparound Collaborative. We warmly welcome Attorney Collens and thank you for presenting with us today.
Well, thanks for having me. I appreciate the warm welcome. Boy, listening to LaToya, I mean, I always like listening to her because she's got so much great information, but it makes me both sad and angry that people take advantage. But I think that her information is so helpful to be cautious and aware. So thank you for the presentation, LaToya. Thank you for having me this afternoon to talk. My presentation intention is to think about planning in the midst of a pandemic for things that are happening actually outside of the pandemic world and have been happening for a long time, will continue to happen after the pandemic occurs. But I think that COVID has put a greater focus on areas like estate planning and what happens when a person grows incapacitated or when a person dies. So let's get started then. If you could switch to the next slide, please. I want to give us some context. As I say, the COVID crisis has brought into focus things that were going on previously, but are now more intensely felt. And so I want to give you a notion of how estate planning sort of looks in the broader world. Caring.com does an annual survey of the general public in America about estate planning usage or lack of usage. And what they report is about 60% of Americans say that having a will or trust is very or somewhat important. However, even though we say that is a majority of us, 2 out of 3 adults still don't have a will. And so, you know, it's the age-old problem of knowing something is important to do, but not getting around to doing it, or not wanting to, or perhaps not having the financial means to get it done. Of the people who are 55 and older, only 44% of that group have estate planning documents in place. And so that is sort of challenging for that population. Obviously, as we grow older, the likelihood of us growing incapacitated or in fact dying is increased. And so not having estate planning documents in place leaves a significant gap in needed coverage and perhaps makes things much more complicated when those eventualities arise. If you turn to the next slide, please. So the other interesting thing that caring.com survey showed was that 1 out of 3 people said that COVID had caused them to see a greater need for having an estate plan, but 31% of those people who saw a greater need still didn't do anything about it. And so you're left to wonder what's, if people are looking at this and saying, well, we really should be doing something, but they don't take the action, what is causing that gap? I don't have a good answer for it. I mean, I think that, as I said before, I think part of it is just finding people locked into old ways. In other words, that they don't expect to become incapacitated or don't really think they'll die anytime soon, so they don't start acting. Perhaps it is the isolation of our times where they don't get out like they used to. Although I'm here to tell you that many estate planning attorneys are meeting with clients remotely, like we're doing here, talking to each other on Zoom and getting things set up. And in fact, there are ways to get things signed remotely without actually having to meet with an attorney in person. And again, it could be financial. Obviously, the pandemic has caused significant financial hardship to many people. And so someone who might recognize the importance of having a document set up, but just simply can't find the means to do it or don't have the means to do it. Go ahead to the next slide. So I want to focus our attention on the kinds of things that happen when a person grows incapacitated, but doesn't have a written plan in place or doesn't have an effective written plan. Because it is possible, even if you have a written plan, it's not effective enough to get the job done. And so there are 2 main outcomes in those cases. The first is guardianship, and a guardian is a court appointment of a person through the probate court who the guardian is given authority to act over a person's welfare, making sure that they have a place to live, making sure that they're fed and clothed, making sure their medical needs are met. That guardianship, and we'll talk a little bit more about how those get set up in a second, but the guardianship is intended to provide a person's general support of a non-financial component. Conservatorship, in contrast, is to deal with a person's financial affairs. So a person who has any sort of means, whether it's real estate or money in the bank or investments, and if that person grows incapacitated without a written plan, then the probate court is the place to go for that person's loved ones to get a conservator appointed to handle financial affairs for the incapacitated individual. Let's go to the next page, please. So I want to dig in just slightly about, and forgive me, I know that we only have about 40 minutes or so to talk here. So I unfortunately, this is a cursory overview of the whole discussion, but I want to at least highlight these things so you understand them in a basic way. And then if they apply to you in particular, then you'll obviously need to do some further investigating. The establishment of a guardian requires that the person be determined by the court to be legally incapacitated. And that means that they have some type of impairment that's defined by statute. Either it's mental illness, it could be physical illness, it could be because of their chronic use of drugs or intoxicating liquors, or some other cause. It could be temporary, so it could be someone had a stroke and is now unable to manage their own affairs, but will be recovering, hopefully. And then once they gain the recovery, then the guardianship will stop. Or it could be something ongoing. Think about someone who's developed dementia, and that's not going to be reversing. And so once a guardian is in place, that is likely to be in place until the person passes away. It has to be necessary to provide for the person's continuing care and supervision. There's going to be an evaluation of whether there's a less restrictive means. So if a person does have a written plan in place that is workable, then that might avoid the need for a guardian. But if someone doesn't have any written plan at all, then the guardianship could be the best kind of outcome to help a person be maintained. And this could include important medical decisions, including end-of-life decision-making. So, in COVID times, of course, we come across these great realities and hardships about the illness and the significant impacts. And hopefully with the spread of the vaccine and more people taking it, we'll have less and less deaths due to COVID. But the reality is right now, we're still seeing enough that in my office is still seeing people dying of COVID. So we need to have these guardianships in place when a person grows incapacitated. A guardian can be appointed on an emergency basis. Typically, the court process is a longer one, though, measured in several weeks, I should say, between the time the petition is filed and the hearing is held to have the appointment made. Let's talk about conservatorships for a second. If you go to the next slide. So a conservatorship is similar, as I said, to a guardianship, but this is dealing with the financial affairs. It requires that the individual be unable to manage their property or affairs. Again, similar incapacity issues, mental illness, physical illness, other disabilities, drug use, intoxication. And then it also has to show, and go to the next slide, please, that the person's monies will be wasted or dissipated without proper management of them. Or because they're not taking care of their own financial affairs, they need the support for care or welfare. The conservatorship also can be established by a person who is not necessarily incapacitated in the sense that they still are able to manage their own affairs, but they know that due to their age or infirmity that they're unable to manage their own affairs effectively, and that they would benefit from having someone else serve in the role as conservator to help them out, to be able to manage their financial affairs. Those are more unusual, but they happen. I see them come into my office in circumstances where someone has, well, in great numbers, in the majority of the numbers of cases where they have had bouts of mental illness over time and have finally come to the realization that having someone help them with their financial affairs makes a lot of sense. I'm thinking about a person suffering from manic depression, where in their manic phase, they spend uncontrollably, but they've come to realize that manic approach leaves them open to improper spending. And so by having a conservator, that can be limited or stopped altogether. All right, let's go to the next slide, please. So guardianship and conservatorship are the outcomes when a person hasn't done written planning in advance of their incapacity. But I'd like to have us, because the people on this call obviously are proactive, you're taking advantage of learning to consider things. Having a written plan could avoid the need for a guardianship or conservatorship in many cases. And so I want to focus our attention next on three types of plan or types of documents that can help avoid the need for guardian and conservatorship upon incapacity. The first that we'll look at is a financial power of attorney. The second is a patient advocate designation. And I also want to spend a few minutes talking about a HIPAA release. We'll talk about what that is and what it does. All right, so let's look first at a financial power of attorney. What this does is it's a document, a drafted document that allows a person to name someone else to act as an agent on their behalf. The good part about the financial power of attorney, it does not require court involvement to get set up. The person who is the principal, the person setting up the document, names the agent. The person who is named as the agent, the official title for that position is called attorney in fact. Now, the person does not need to be an attorney to serve as the agent. So, the problem in law is that we're stuck with names of things that were previously set in place. So unfortunately, they weren't marketing people when they set these things up. So it's calling it the attorney in fact is the name of the position, but it does not as I said, have to be an attorney to do it. Most times it's someone like a spouse or a child or a very close friend who's reliable. Those are the most typical agents who are named. It's important to name someone, obviously, who has your trust, because they're going to be doing important work for you on your behalf, and they need to be trusted to do the work correctly and in your interest. Powers of attorney can be effective either when they're signed at the time of the signing or upon incapacity. So most powers of attorney that I draft, I like to have them effective immediately. Most of my clients end up naming spouses or children, so they're usually acting with these people anyhow before they sign the document in my office. But the reality of it is that they're naming someone that they trust, and so having immediate ability to act is useful and important. Having it as a springing power effective only upon incapacity can prove complicated depending on the incapacity that the person is facing. A springing power would only come into effect to be used if the triggering event occurred. And the triggering event typically would be some sort of doctor review of the person who was the principal, saying that that person was no longer able to manage their own affairs, such that they needed the agent to start acting. You know, in some instances, that's pretty easy to figure out, right? A person has a stroke and isn't able to answer questions or to read or write, you know, because of their illness, then that's pretty clear. They're incapacitated, then the agent should start acting. Think about a dementia case, though. I mean, unfortunately, with that illness, it is not always apparent when the person has grown so far incapacitated, springing power should start. And some doctors are reluctant to write that letter before the person is fully far along, but the individual is starting to make bad decisions for themselves or not acting properly, not paying bills, right? Things are just stacking up. And we see that a lot, where the person has started to just ignore things because of their oncoming illness, but the agent still doesn't have authority. And unfortunately, in those kind of cases, what we end up doing is going into the probate court and asking for a conservator to be appointed. So that's a long way to say that I think that there's a lot of benefit for having an immediately effective financial power of attorney. The language that is also used that is sometimes confusing to people is that these are called durable powers of attorney. And let's talk about what durability means. So that's a technical term which describes that the document is effective and it stays in effect even though a person is grown incapacitated. That's the durable part. It's durable through the illness. Powers of attorney can be canceled by the person who's created them at any point, as long as they have the capacity to do so. If they never cancel the power of attorney, then that document will stay in effect until the person passes away and dies. And at that moment, then the power stops. And a lot of times fiduciaries, the agents are not aware of that and will continue to act, but that's not appropriate. It's, once a power of attorney principal has died, then that power stops with them. Let's move on to the next slide, please. So let's talk about the kind of powers that a power of attorney grants. The biggest ones that most people are looking for are banking powers. So dealing with banks, Social Security, pension, taxes, the kind of day-to-day things, being able to write a check, being able to access the bank account and learn about the balance in the accounts, or who's put money in or who's taken money out. Dealing with litigation, dealing with care issues. So it could be signing a care contract. That's an important element of what powers of attorney agents can do. Includes more extraordinary powers, like powers to make gifts or to create or amend trusts. Now, interesting, in Michigan, you can't grant someone else the power to create a will for you, but you can grant the power to someone else to make a trust on your behalf. So those powers can be really useful to manage and preserve assets, or it could be useful if you have assets to potentially use a newly created trust to help qualify for need-based benefits, like Medicaid for long-term care and things like that. All right, let's move ahead. So I want to focus our attention next on a patient advocate designation. So in Michigan, we offer what's called a patient advocate designation to allow the patient to appoint someone else, the agent, in this case called the patient advocate, to make medical decisions on behalf of the patient if the patient has grown incapacitated and can't make those decisions for him or herself. So the patient advocate designation deals with applying or withholding medication, medical treatment, deals with end-of-life decision-making. It crosses over into what people typically think about as living wills. Again, on a technical level in Michigan, we don't have a statute that directs living wills, but many practitioners will, in the patient advocate designations that I see, like the Michigan Hospital Association form, include living will concepts. So the living will concepts being how end of life should be dealt with. The patient advocate is to look to the document to determine what power is granted and then comply with it. The patient's wishes are the ones that should be carried out. The advantage of having a patient advocate designation is it does not require probate court involvement to either set up the document or to utilize it. Now, the patient advocate designation is a springing document. It's only effective upon incapacity. Go to the next slide, please. So the incapacity determination is made by two licensed professionals. The statute specifically spells out the person's physician and or another physician or a psychologist. Two people, two medical professionals, need to make the determination in writing that the person is grown incapacitated such that they can't make their own medical decisions. And if that evaluation has been conducted and determined that the person isn't in fact incapacitated, then the patient advocate would start acting. The person, if they have religious objections to an examination, need to specifically set that out in the designation itself. So it needs to be clear in the document if that is in fact something that's applicable. It is also important to have an eye towards HIPAA in the patient advocate designation. So HIPAA, I guess we'll pick it up here because I don't know if I specifically describe it in the slides. HIPAA is a health privacy law that has been around for decades at this point, and it limits who has authority to learn about your medical condition. We go to doctors all the time and they have us fill out a HIPAA release. And if you read those releases, and I happen to because I'm an attorney and I like to read that sort of stuff, when you read them, most of the time it says, I give authority to release information to other doctors or hospitals or insurance companies. But it fails to remember that we have family or friends who might want to learn about our condition. And so having a standalone HIPAA release is important, especially one that specifically addresses the fact that we want our medical information to be shared with our loved ones. It's not technically a power of attorney, but having that standalone release is really a useful tool, especially in medical emergencies, to be able to have people learn about what's going on with you. I also, in my drafting, include HIPAA release language in the patient advocate designation itself, as well as in my financial power of attorney, because sometimes there's a crossover between medical stuff and financial stuff, so that the medical information or access to medical information will be important as part of the financial power of attorney's activities. A lot of times, by the way, people will name the same agents for both of these kind of documents. So you'll name the same agent for both your financial decision-making and your medical decision-making. And that makes a lot of sense, right? I mean, if you have a spouse, most of us look to our spouses to help in those situations. And so to name them as the agent across those decision-making places makes a lot of sense. All right, let's move to the next slide, please. So, I get questions a lot about who to name as a patient advocate. And obviously the top priority is it has to be someone you trust. As I said, most typically it's a spouse, child, or a friend. Although I can tell you, I just reviewed an estate plan with a client who did not want to name her spouse as her patient advocate because she told me that the person, her spouse, would not make the kind of decisions or could not make the kind of decisions that would be necessary if she named him as her patient advocate. So it's not required that it be your spouse and your children. It could be other people altogether, but it's important to have. Can you name more than one person as a patient advocate? The answer is, like a good lawyer, it depends, or maybe. What do I mean by that? Well, so there's some difference of opinion among lawyers, and I don't believe that there's been a Court of Appeals or Supreme Court in Michigan decision on this topic. The statute itself references a patient advocate, which would suggest that it would be one person at a time. There's commentary on the statute, though, that suggests that you could name more than one person at a time. So, I mean, my general practice is to suggest my clients really name one person at a time, as opposed to naming two or more at the same time. I also remind folks who might want to name more than one agent at a time that it's complicated if you do that. I remind people it's like running a three-legged race, the kind of race where they take two people, tie their close legs together, and then they make them run from here to there. And some people are really successful in making the journey from one end of the thing to the other, but others fall down or never make it all the way across. And it's the same kind of thing when you name multiple agents at the same time. If they get along well and can make a common decision, terrific. But if they are fighting or disagreeing or whatever, then the decision might not get made in a timely way, or it might not get made at all, or they might end up in court fighting about it, which obviously is not desirable. So a word of caution about naming more than one agent. All right, let's move to the next slide, please. So I want us to next focus, we've talked about sort of the importance of doing planning for incapacity. We've also talked about what happens if you don't plan for incapacity. I want us to next focus on death and dying and the planning in the situation where a person has died but doesn't have a written plan in place. And as you know from the very beginning of my talk, the great majority of us don't have a written plan at all. So this will talk to the great majority of people. My hope, by the way, in talking about this talk is that I will convince and entice you to actually do your planning if you haven't already. Or if you have, then it's probably time to review it. So dying without a written plan. What happens is that the laws in Michigan provide a mechanism for distributing a person's assets who's died without any will in place at all. There is the laws of intestate succession. Technically, intestacy means dying without a will. And there's a statutory priority that's out there then that describes who takes what out of the estate. For many people, that will be fine. It'll match exactly what they would have otherwise wanted in writing. But for some, it will not match at all because they have an unusual family circumstance or a different intent. But unfortunately, if they never took the time to put things in writing, then it doesn't matter whether they had an intent or not. Spouse is given the highest preference and benefit from intestate distributions. And then children and grandchildren are included if there isn't a spouse, or if there's a blended family, then it gets a little more complicated. And I'm not going to go into the details of that necessarily, except to say that the law will figure out who the heirs are and determine, based on the laws of intestate succession, who will take. So who are your heirs? If you're married, your spouse is your primary heir. If you have children and no spouse, then those children. If you have children, but they've died, leaving children of their own, your grandchildren, those grandchildren would take. If you don't have spouse or children or grandchildren, then the law looks to see, do you have surviving parents? If not, siblings, then nieces or nephews. If none of those people exist, then the law says look to see if you have grandparents on the maternal and paternal side. And then if you don't have those folks, do you have aunts or uncles? Do you have cousins? It is not unusual in a situation or it can be, these are more unusual. I guess I should probably restate that. It's unusual to have this sort of case, but it is possible in a situation where you don't have a written estate plan and then the person dies, and then there are people who may have never met this deceased person who's now receiving a share of an estate. Think about remote and distant cousins who might still be included in the distribution, but again, would never have had contact with the person who had died. So it's not desirable in that sort of case. But for many people, it won't matter because their spouse is alive, and so the spouse will take the entirety of the estate, or their children are alive, and so they'll split it up. Let's move ahead to the next slide. Even with an unwritten plan, there are some assets that will go and pass outside of probate. And those assets include jointly held assets. So if you have a joint bank account with someone else, or jointly held real estate, think about spouses holding a house together, then those assets, when the first spouse dies, will pass to the survivor, and there's no probate for that transfer. Think about beneficiary designated assets like insurance policies or IRAs or 401ks, 403B, 457s, any of those kind of deferred assets. If there's a beneficiary designated, then that designation will control and allow those assets to pass. Those transfers are not going to require probate court involvement in the great majority of cases. Now, if people are fighting, then that kind of asset could end up in the probate court for the judge to look at and decide. But again, most cases are uncontested, and so those designations or jointly held assets will pass outside of probate. Go ahead to the next slide, please. So if you have a written plan, if you have a will in place, then the will control assets that are in your name only, without a joint donor, without a beneficiary. Those assets, in order to pass, will go through the probate process after your death has occurred. The will allow you to describe who's going to be in charge of that administration, so it allows you to name the personal representative. The personal representative is the name for the person who administers the estate. It used to be called executor, but it hasn't been called that for a long time. So you'll sound all modern if you call it personal representative. If your intention is to disinherit someone, then having a written estate plan is a must. Think about that circumstance where you have a child who you don't want to leave a share to. You'll need to say that specifically in the will to make sure that that child does not receive. If you're charitably inclined, if you wanted to leave a gift to charity, you need to spell it out so that that can be affected when your death occurs. As you probably heard, or as you didn't hear me say when I was going through the list of heirs, charity is not part of that. So if you are intending a portion of your estate to go to charity, then it has to be somewhere in writing. And that could obviously be as a beneficiary on an insurance policy or a 401k or IRA, or it could be as a beneficiary of a bank account, for example. But typically, if people are going to leave a gift up through their estate, they're going to want it in writing and do that through like their will. Let's go to the next page. The benefits of having a will are that they're relatively simple to establish and maintain. And as I said, you get to name your personal representative. Let's move ahead, please. Oh, and you know what? I didn't put a slide of this together, but I guess I should spend a couple minutes talking about probate because I get a lot of questions about this usually. So let's talk about what the probate process is in a general way after a person dies. And this will help, fill in the picture for you a bit. When a person passes and they have assets in their name alone, without a joint donor, without a beneficiary, those are probate assets. And those assets, in order to pass, will have to have an estate opened at the probate court, have a personal representative appointed. The personal representative will be appointed through one of two main processes. Either there will be papers filed with the court and a petition setting a hearing date, and the court will then hear the case to admit the will and determine who the personal representative should be. That's more unusual. The more typical process is that an application is filed and an informal process is made where the proper papers are filed with the court, and there is no specific hearing. If the papers are all filed in order, then the court will issue what's called letters of authority. And those letters of authority give the personal representative the authority to act over the estate. The great majority of estates that get open informally by this application process. Now, one of the problems in the time of COVID is that the courts are all closed. Like, you can't walk into them. And so the processing times have increased significantly, unfortunately. What that means, in Wayne County, it could be, about a month before you get the papers processed and back. It could be longer than that even to get your hearing if you're going to set up for a hearing. So once the estate opens, though, the personal representative is given authority to act over the estate. They'll give notice to creditors that the estate exists. Creditors will have typically 4 months to make their claim, and they'll be dealt with if they come forward. And if they don't, then they won't be considered and won't be paid. The persons who died, that person's tax returns will have to be completed. And then the assets will be distributed under the terms of the will, if there is a will, or under intestate succession, if there is no will. The typical estate process through the probate courts takes somewhere between 8 months to a year. And a lot of that time is waiting for the creditor claim period, that 4-month period. It's not going to take much less than 6 months in any event. And it also will depend on when the taxes, when the person dies in the year, because their taxes will need to be prepared, right? So if you think about a person who dies in December, their tax information will come January, February, March, and those returns will be able to be filed in April. And so we'll be able to close that estate out fairly quickly, assuming everything else is dealt with. Think about the person who dies in January. We're going to have to wait till the following year to get their tax returns in order. Let's talk about a trust for just a second. And I know I'm coming to my end of my time, so I don't want to linger too long here. A trust is another written planning option that can be a valuable approach to setting up an estate plan. And what it does is it gives you the ability to set up an entity, a trust. It's a contract, it's a pile of paper that allows you to nominate someone to serve as the trustee and manage the affairs of the trust. The trust, and the kind of trust I'm thinking about here, is a revocable trust, a revocable living trust. It gets set up while you're alive. You'll typically name yourself or yourself and your spouse as the co-trustees of the trust to manage it while you're alive. Upon the death of the first of the trustees, then the survivor will continue to act. On the death of the second or the remaining or sole trustee, then a successor will be named. The advantage, one of the advantages of having a trust like that is that it doesn't require probate court involvement in many instances. And so the administration while you're alive, if you've grown incapacitated, will happen without having to go into court for that guardian or conservatorship. And the advantage at your death is that the primary administration of a trust is generally not happening through a probate court. And so the administration is a bit, it can be easier. It doesn't have to be, because sometimes it's complicated, but it can be easier in a lot of instances. The trust will still need to deal with creditor claims and taxes and all that after a person has died. But as I said, it will generally be a little bit of a smoother proposition for the administration itself. Trust can also be used in situations where a person has an inheritance taxable estate. Now, these days, the inheritance tax exemption is well over $11 million. So if a person dies with less than $11 million, there's not going to be inheritance tax to pay on that estate. But if they have an estate that's over $11 million, then it may be worth doing some special planning to minimize or eliminate that tax burden. Let's go to the next slide, please. As I said, the trust is a little bit more complicated to set up and maintain, but it has some advantages. As I said, these are distribution or transition, I should say, upon disability or death of the person who's created the trust. But there is still administration. Let's go to the next slide. So as I wrap up and conclude here, I would urge you to take some action, to do something in response to hearing this talk. And what I'm thinking about is to the person who has no written plan in place, that I hope this spurs you to explore getting a written plan. The benefits of it are substantial, and as I've hopefully described, the downsides of not having a written plan can be pretty significant. What I recommend is that people who have a written plan pull them out and review them, and typically on an annual basis, making sure that the person who you've named as your agents and the fiduciaries and the fiduciary role are still the right people, and that the distribution that you've intended, that you currently intend, matches what you drafted in the document. And to the extent that any of that's changed, that you make updates for doing this. One last thing, though, is a word of caution, which is about doing this yourself. Now, you know, the one of the great benefits of the internet is that there are a lot of documents available, legal documents available for download pretty simply. That's good on some level, but it's also a trap. And what I mean by that is that, and this is true even about filling out a form that you might buy at a store, because those forms exist, and I'm not saying that they don't serve some purpose, but what they do is they offer an opportunity to do things for yourself where you might not be aware of the implications of what you're doing. You might fill things out improperly. And I'm here to tell you that in my experience, the cost of setting an estate plan up properly on the front side is often dwarfed by the cost of fixing something that's been messed up after a person has grown incapacitated or has died. And so I offer a word of caution about doing it for yourself. As I like to say, not many of us change our own oil. Not many of us cut our own hair. We want to make sure that we're not doing lawyering on ourselves, especially if it's your first time, right? It's a trap. So, you know, there are really good resources out there, but be careful when you use them, or if you do. Seeking the advice of a sage attorney to help draft these is a really good thing to do. All right, if you go to the next slide, this is my contact information. If this talk has generated questions that you would like to ask in the chat, by all means, I'm happy to answer questions right now. If you prefer to contact me privately to ask questions or whatever, here's my information, and please do feel free to call me at my office. I know there's some folks on the phone who might not be seeing the slide, so my phone number is 248-545-2500, and I will look forward to speaking with you then. With that, I'm going to stop, and I will take any questions that this might have driven.
All right, we have one question here. What's the usual cost of creating a power of attorney, and what are some of the steps that we would want to follow?
Sure. So I'm going to answer those in reverse order. So let's talk about the steps, and we'll talk about the cost. So in terms of the process for planning, the way I approach it is I like to send a questionnaire out to my clients. The questionnaire is going to ask them to gather information about themselves, about the assets they hold, what their intention is, like who's going to serve in which role as power of attorney agent, and in which order. And then once we've confirmed that information, then the drafting is pretty straightforward. Powers of attorney are relatively easy to set up, which means that they're somewhat more cost effective, to be blunt, than setting up a will or a trust. So to get to the cost answer, and I'll be careful here to say it depends. I mean, attorneys are all different and they charge different rates. So I know that there are some attorneys who will draft a power of attorney for a flat fee and charge a limited amount of money. It could be, you know, some attorneys can be under $100 for a power of attorney. Others can be a few $100s. Not all powers of attorney are the same, as we've sort of described in the talk here. So you have to be careful, and specialization of knowing what to do is important. So, powers of attorney, themselves can be relatively inexpensive to set up. For a medical power of attorney, there are forms available through the Michigan Hospital Association that you don't necessarily need to have an attorney at all. It's a fill-in form, and that you can perhaps do yourself. However, I offer the same caution that I did at the very end with that last slide, which is be careful about filling those out, because even with a patient advocate designation, you can mix things up. And there you're dealing with end of life decisions. So if you mess it up, it is with a substantial potential cost. I can tell you one of the most expensive cases that came into my office over the course of the years is a situation where a person filled out one of those hospital association forms, but on top of it, wrote in the document what ended up being contested as a will. And after tens of thousands of dollars of litigation, we finally figured out what that actually meant, because it was a mess. So hopefully that in a way that's good enough. And if you want to talk about my fees specifically, I'm happy to talk about it, but not on this call, but contact me and I'm happy to discuss that. Any other questions that I might address?
No, I am not seeing anything in the box. If anybody else has questions, again, please use the chat or the Q&A function here. We do have a few thank yous for the wonderful information, so we appreciate that. Vanessa, I think I'm gonna send it off to you. I think we've hit our time here.
Thank you so much. So a big thanks to both of our speakers today for such wonderful presentations, and thank you to everyone that has joined our Lunch and Learn. Today's presentation has been recorded, and we will upload all of our Lunch and Learn recordings to our website. So if you want to share this recording with anyone, please do so. You'll be able to do that from our website. If there's anyone with us that's not currently a member of the Healthier Black Elders Center program and would like to join, we can sign you up over the phone. You can call our office at 313-664-2616. So thanks again to everyone. Please stay safe. And our next Lunch and Learn will be in April on Wednesday, April 21st, and it will be with a podiatrist as our speaker. So thanks again. Take care, everyone.